Hello, my name is Terry Gorry and I'm a solicitor in Enfield in County Meath. This presentation is just going to take a look at how to actually carry out a disciplinary procedure in the workplace. So I'm going to give you a step-by-step guide, and if you're an employer, it's going to help reduce the chances of a successful unfair dismissal claim being brought against you. Sacking an employee is obviously a very serious matter. It can have very serious consequences, going far beyond the simple loss of an income or a job. It can also have a significant stigma attached in society. That's why third-party bodies like the Employment Appeals Tribunal, the Rights Commissioner Service and the civil courts are so keen that an employee is given fair procedures and natural justice in any decision to dismiss or carry out a disciplinary procedure in the workplace. An employee, regardless of what a staff handbook may say or regardless of a contract, has a constitutional right to fair procedures and natural justice. It is a fact that roughly 80% of unfair dismissal claims are actually won because of the absence of fair procedures in the dismissal. In other words, they don't actually hinge or are not lost on the basis of the actual offence by the employee, but are decided rather on the facts of the procedure used to carry out the dismissal. The problem is that most employers simply do not know what they should be doing. So remember, an employee is always entitled to fair procedures and natural justice, because these are constitutional rights. The first stage in most disciplinary procedures would be a verbal warning. So generally that will be your first port of call if there is a transgression or a problem with the employee's conduct or performance. However, this will depend on the problem and its seriousness, because there's nothing to stop you commencing the procedure at a different stage. In other words, a more serious issue may require dismissal, for example, for gross misconduct, or a first written warning, or perhaps a second written warning, or a final written warning, or whatever. So you're not bound entirely to the graduated steps that I'm going to refer to in this video, but generally the steps would be graduated, and the first one would involve a verbal warning. This would involve essentially a meeting with the employee, at which the employee would be told that they could bring a colleague or other representative. Now, this other representative would not include a solicitor. There's no entitlement for an employee to bring a legal representative. At the meeting, the employee should be advised of what the problem is and invited to respond and explain his or her actions. Following the meeting then, a confirmatory letter should be given to the employee. This letter confirms that the employee has been given a verbal or oral warning. It should also contain the improvements required of the employee in respect of the behaviour which led to the warning and the time frame within which the improvement must be made. The letter should also state that failure to improve will lead to the second stage of the disciplinary procedure and perhaps ultimately dismissal. You should also note or state the time period for which it will remain on the employee's file, after which it will be removed. 3 months would be a reasonable period for the first verbal warning to stay on file, but again, it's up to the employer. You could take 4 months, you could take 6 months, but you really do need to be fair, and 3 months generally is considered to be reasonable for a first warning, a verbal warning. Once this disciplinary procedure has commenced, the employer should assist the employee to improve the conduct or performance, whichever was the source of the problem in the first place. The employer should record the details of this 3-month monitoring period, and retraining or relocation should be considered, if possible and reasonable. If you're a very small employer and you've only one place of work, maybe one shop unit or one factory, whatever, then clearly relocation is really not going to be a possibility. So that, it will depend on the circumstances. The second stage then of your disciplinary procedure should be a written warning. So we're talking about a first written warning. If the employee fails to improve, or there is a repeat of the activity that caused the oral warning in the first place, the employer can then issue a first written warning. Before issuing it, the employee should again be invited to another meeting, told of the problem, the transgression, and given the opportunity to respond and put his or her side of the story. This written warning will then be issued and last for another 3 months, so probably you're looking at 6 months in total that the person will be monitored for their either conduct or performance. The warning should also clearly set out the nature of the problem, suggest solutions such as retraining, and advise of the possible sanctions, including dismissal, if no improvement is observed within the next 3 months. The employer should again afford all reasonable assistance to the employee to help him improve in conduct and or performance, again whichever is the nature of the problem. If the required improvement is not forthcoming, then a final written warning would be issued with a 6 or 12-month monitoring period. The letter confirming this warning will advise that if there is no improvement, or if the bad behaviour or performance is repeated, then dismissal will occur. This letter needs to be drafted carefully because it will be scrutinised very closely by the employee and his or her legal advisor in the event of a dismissal. If there's no improvement then after the final written warning, then a dismissal is the likely outcome. A meeting should be called and the employee and his representative invited. The employee should be given the opportunity to appeal within 14 days. He should also be given a letter confirming the dismissal and the right to appeal, the time period for the appeal, and the procedure, who to appeal to. Now, this disciplinary procedure that I've discussed in this video may not apply in the circumstance of, for example, gross misconduct. It also, as I said at the outset, may commence at a different stage depending on the problem and the seriousness of the problem. The key thing about this procedure and disciplinary policy generally is that fair procedures and natural justice must be afforded to the employee. The employer then is much less likely to lose an unfair dismissal claim by his or her former employee. My name is Terry Gorry. I'm a solicitor in Enfield and County Meath. My contact details are on the screen there, as you can see. You can call me or email me or visit either of those websites and you'll get more free information about employment law and about what we do. Thanks for watching.